Judges of the Caribbean Court of Justice.
Please take your seats. Caribbean Court of Justice, original jurisdiction for the delivery of the reserved judgment in the four consolidated matters as follows. TTOJ number 1 of 2018 between Trinidad Cement Limited versus the State of Trinidad and Tobago, Rockhard Distribution Limited, Motilal Ramhit and Sons Contracting Limited. Number 2, TTOJ2018-002, Trinidad Cement Limited and Iraq Cement Company Limited versus the State of Barbados and Rockhard Cement Limited. Number 3, SLUOJ2018-001, Rockhard Distribution Limited versus the State of Trinidad and Tobago and the Caribbean Community. Number 4, BBOJ2018-001, Rockhard Cement Limited versus the State of Barbados and the Caribbean Community. Can we have the appearances for the court, please? Thank you.
Good morning, Your Honours. May it please the Honourable Court. Mr. Reginald Armour, Senior Counsel. Mr. Gilbert Peterson, Senior Counsel. Mr. Gregory Panton. Mr. Rafael Jr. leads me, Miguel Vasquez, in these consolidated matters. Your Honours, we do apologize for the absences of Mr. Peterson, Mr. Panton, and Mr. Jr.
Your Honour, should it please you, Mrs. Deborah P. leads me tomorrow to listen to the State of Trinidad and Tobago. We are the defendant in claim number 1, contracting party in claim number 2, and the first defendant in claim number 3. We are instructed by Mr. Brent James and Mr. Wallace.
May it please Your Honours, Mr. Alan Wood QC leads me, Simone Mayhew, on behalf of Rockhard Cement and Rockhard Distribution Limited in the four matters. I apologize for Mr. Wood's absence today.
Your Honours, should it please you, I am O'Neill Francis and I appear on behalf of the Caribbean community. I'm led by Dr. Colita Bab Schaefer and we appear in matters 3 and 4.
I believe those are the appearances that we have this morning. Good morning, Council. I will read a summary of the judgment. Of course, the summary is not intended to be a substitute for the reasons of the court, nor is it to be used in any later consideration of the court's reasons. These proceedings mark the culmination of multifaceted litigation that have so far resulted in 5 separate judgments and numerous orders. In this judgment, the issue before the court was whether the extra-regional cement known as Rockhard Cement, imported into and or distributed in member states of the Caribbean community by Rockhard Cement Distributions Limited, Motilal Ramhit and Sons Contracting Limited, and Rockhard Cement Limited, ought to be classified for purposes of CARICOM's Common External Tariff, or the CET, as building cement grey or as other hydraulic cement. Tariff heading 25.23 of the CET sets out the various categories of classification of extra-regional cement and the applicable tariff for each category. Member states are required to levy a CET of 15% on cement classified as building cement grey, which is a form of Portland cement. And for the category of cement known as other hydraulic cement, the relevant levy is 0 to 5%. Following its 77th special meeting on 28 January 2019, CARICOM's Council for Trade and Economic Development, that's quoted, decided that rock-hard cement was to be classified as other hydraulic cement. And that decision on the part of quoted throughout the judgment we refer to as the quoted classification decision. This decision was made by the votes of 11 member states. Quoted considered that those 11 votes were in sufficient compliance with Article 29 of the revised Treaty of Chaguaramas, the RTC, which stipulates that a 3/4 majority vote is required for a binding decision to be made. The quoted classification decision was heavily influenced by the advice sought and received from the Harmonized System Committee of the World Customs Organization, or the WCO. The committee found that rock-hard cement was properly classified as other hydraulic cement under its widely accepted harmonized commodity description and coding system, that's the HS system. The state of Trinidad and Tobago, Trinidad Cement Limited, and Arawak Company Limited, Arawak Cement Company Limited, were dissatisfied with the quoted classification decision. They argued that the decision-making process adopted by quoted was procedurally flawed, and that quoted had placed too great reliance on the WCO's advice in preference to the objectives of the tariff regime governing the CARICOM Single Market and Economy, CSME. A significant part of TCL and ACCL's submissions was that the economic objectives of the community would be impaired if an extra-regional product were classified differently and was subjected to a lower tariff than a regional product with which it competed. On this basis, those companies contended that rock-hard cement ought to have been classified as building cement grey, and so be subjected to a 15% CET, since rock-hard cement was in direct competition with TCL's regionally produced building cement grey. It was contended that the failure to impose this protective tariff by member states who were importing rock-hard cement nullified or impaired the benefits accruing to TCL and ACCL under the RTC. The court heard the matter over 2 days. On 11 June 2019, witnesses called by the respective parties were subjected to cross-examination and to such re-examination as was considered necessary by counsel calling those witnesses. On the 12th of June 2019, the court heard extensive submissions from the parties and interveners. In its written judgment, the court notes its role in reviewing decisions of organs of the Caribbean community. The court states that as a general principle, it would always accord to the organs of the community the policy space intended by the framers of the RTC. Nevertheless, the court reiterates that it would assert and exercise its competence and responsibility to ensure that decisions of the organs were taken in accordance with both the procedural requirements and substantive considerations required by the legal strictures laid down in or arising under the RTC. The court goes on to hold that there is no procedural or substantive basis for impugning the decision made by quoted to classify rock-hard cement as other hydraulic cement. In particular, the court rejects submissions that the quoted classification decision should be set aside because, 1, the 11 votes of the member states did not constitute the requisite majority in compliance with Article 29 of the RTC, or 2, the state of Trinidad and Tobago is not a party to the 1983 International Convention on the Harmonized System, and so the WCO's opinion has no application to it, or 3, none of the CARICOM member states who were parties to the HS Convention or the WCO Convention were allowed to make representations to the WCO before it rendered its opinion, or 4, the CARICOM CET although adopting the HS model of classification has its own history, which must be borne in mind as an aid to the interpretation of the object and purpose of the RTC and the peculiar circumstances of the CET, and that these were not put before or considered by the WCO. And or 5, the WCO applied technical standards, the ASTM C150 and EN 197-1, when the CET makes no mention of those standards as being relevant in determining classification of cement under tariff heading 25.23. The court agreed with the state of Trinidad and Tobago that the quoted classification decision should have been accompanied by appropriately drafted reasons. However, the court notes that it is reasonable, especially in a situation where quoted had not traditionally given reasons for its decision, to examine the full circumstances in order to determine whether the reasons grounding that decision were, from a practical point of view, apparent. This was necessary also because there may be no breach of the duty to give reasons where the reasons for decision-making were readily apparent. In the circumstances, the court finds that it was clear that the quoted classification decision was based on the advice requested and obtained from the WCO and its HS committee. As to whether quoted erred in relying on this advice, the court emphasizes that all member states participating in the CSME were also members of the WTO, and it was expressly stated in the CARICOM CET that that arrangement was premised on the WCO's HS Convention and adjoining explanatory notes. The court therefore finds that quoted was fully entitled to place heavy reliance upon the advice sought and obtained from the WCO and its HS committee, given the role of the WCO in harmonizing rules on international trade within the context of the WTO. The fact that no member state made prior representations to the WCO did not significantly undermine the integrity of the WCO's decision. The court did not agree that quoted failed to give relevant weight to the fact that rock hard cement competed with cement produced regionally by TCL and ACCL. Any such alleged failure may very well be relevant to tariff setting, which involves an exercise that is entirely different from classification. The court found that classification involved placing a commodity under its proper HS tariff heading, having regard to its composition and physical characteristics. It was a matter of policy for quoted to decide upon the level of protection to be given to regional production as against competing extra-regional goods, within the limits of any relevant international obligation, whatever the classification of the extra-regional goods may be. That protection may be given by adjustment in the rate of the tariff, not by classification. While it upheld the quoted classification decision, the court also makes the following general comments. First, the recent development in the cement industry, which has made possible similar performances by Portland cement produced regionally and by rock hard cement imported from outside the region, probably makes it appropriate for a study to be done by quoted so as to assess whether the tariff rate imposed for imported other hydraulic cement ought to be increased to accord an appropriate level of protection to regional manufacturing of both Portland cement and blended cements. That study would no doubt consider all relevant factors, such as the employment generated by the regional product, the security of supply, the quality of the product, and economy to consumers. The conduct of such a study would be entirely in keeping with the treaty obligation on quoted to keep the common external tariff under review, Article 83(5) of the RTC. Secondly, the court had been informed by the parties that member states of CARICOM did not all maintain the same bound rates in their WTO schedule of concessions. The court recommended that member states, through quoted, should consider greater collaboration in policy making in relation to trade between the community and the wider global community. Finally, the court said that it may be useful for quoted to consider initiating the implementation of a project aimed at harmonizing the classification of goods based on WCO standards with the objective of enhancing CARICOM trade. This might involve a diagnostic mission to assess the existing infrastructure of member states regarding the harmonized system and tariff classification, as well as customs valuation. The specific goal would be to build the capacity of the customs administrations in drawing up, implementing, and managing their national systems of classification so as to be compliant with the HS Convention, as well as with international and regional standards and best practices. In light of all the court's conclusions, the court upholds the quoted classification decision as being binding on all member states pursuant to Article 29(1) of the RTC. Rock hard cement is therefore to be classified as other hydraulic cement, on which member states should levy a CET rate of between 0 to 5%. The originating applications on TCL and ACCL are dismissed, and the parties are asked to make written submissions on costs. The judgment, if it has not already been given to council, would be made available and will be posted on the website. In particular, you would note in the judgment that we have asked the parties to make written submissions on costs. We have asked that those submissions not exceed 5 pages, and I'm not sure whether we gave a timeline for the making of those submissions. 6 weeks, yes. Thereafter, we will make a decision on costs. And Justice Barrow, who has signed the judgment, has he's asked to have his absence excused.
Just one question, Your Honor, in relation to the order with regard to costs, whether we should make provision for reply submissions, because I gather they will not be simultaneous, but there may be issues raised in another party that a party will wish to respond to. So I think that would assist the court. I respectfully submit.
Yes, I agree entirely. I'm just considering in my mind whether we ought not to have the submission staggered, perhaps, and that would obviate that. So that perhaps we could amend the order, which is in the judgment, to say that the successful parties shall submit their entitlement to costs, and in particular, the quantum. And when we say the quantum, we don't mean a dollar figure, we mean the percentage of costs to which they consider they should be entitled, and they should do so within 4 weeks, and the unsuccessful parties should respond maybe 3 weeks within 3 weeks thereafter. So, okay, you want to get down to dates? So let's get down to dates. 4 weeks would carry us to when?
3rd of September.
The 3rd of September. What day of the week is that?
Tuesday.
A Tuesday? Okay, so that the successful parties will make submissions on costs on or before the 3rd of September, and the unsuccessful parties will make reply submissions on or before the 24th of September.
Thank you for that, and to my little friend, Mrs. Peak. Your Honors, in addition to the clarification that we've just obtained on the submissions on costs, would the court consider outlining a timeline for the diagnostic study that the court recommends should be made?
We'll do that. Yes. That's just a polite recommendation of the court to quoted, so we couldn't give timelines on that. Of course, affected parties are free to lobby quoted as they may wish to, but we couldn't go there.
As it be, much obliged.
Your Honors, just a clarification in relation to rock hard cement. As you will recall, I didn't hear all that Mrs. Peak had said, so I'm not sure if she had referred to this, but there was a previous judgment on the issue of the derogation, and no order for costs had been made in those proceedings. And I just wanted to clarify, one, whether or not these submissions on costs should also cover those proceedings.
Yes.
And also, okay.
Yes, the submissions should cover those proceedings as well.
I think
And
in
I also,
all those proceedings, I think the decision was reserved, so.
yes. And I noted that the court has not indicated who the successful parties are, and I submit that the court wishes the parties to make submissions as to whether they are the successful parties.
Are you in doubt?
I'm not in doubt, but I am. I'm looking at the declaration. So, for example, as you recall, we had filed a claim in SLUOJ2018, and I know that no specific declaration was made in the disposition with that, although the court has made a declaration that disposes of the issue of the classification therein. So I just wanted to be sure that the submissions would also cover that case. Okay. In that case, Rock Hard Distribution and the state of Trinidad were the only parties, I believe.
Maybe a convenient approach to the 5 pages that each side has would be you put a heading of a case in which you were a party, and you indicate what, if any, entitlement to costs you think you are due, and you go right down the list like that. So you do it case by case. You disaggregate the consolidated cases, and you indicate your entitlement and the percentage, quantum of costs that you think you are due under each. So that I would imagine, because the successful parties are going first, so that yes, you do that, and then the parties that would be bearing costs would be responding to what is stated there.
There is just one other issue that I'd like to trouble the court with, unfortunately, and it arises from the derogation issue. I know we're here about classification, but on the delivery of that judgment, there were some issues that remained outstanding, particularly in relation to the order for interim measures, the question of an inquiry as to damages, the question of a refund. The court had encouraged the parties to try and resolve it amicably. The court may have seen that Rock Hard Cement has filed an affidavit yesterday, yes, and our efforts to try and resolve that amicably with the state of Barbados have been futile. So, by way of inquiry, I'm asking if the court would consider directions herein to determine whether or not there are any outstanding issues to be resolved in that matter. That would be BBOJ number 1 of 2018, and to a certain extent TTOJ2018. These are the Barbados cases, because despite our repeated efforts, we have not been able to resolve the consequential issues in relation to the refund and an indication of what the rate is going to be going forward, and any damages that may have arisen as a result of the injunction, the interim measure.
Your Honors, if I may rise, hopefully for the last time, and I don't rise in response to the inquiry that Ms.
I'm afraid I'm not here, Mr. Amor.
I rise to, hopefully not for the last time, to repeat myself, or hopefully for the last time, and I was saying, Ms. Mayhew, may it please the court, that I don't rise specifically in response to what Ms. Mayhew has just said, but in what I'm about to say, the court may consider a middle passage, hopefully, why I rise is to make the observation in the ordinary course of a court delivering judgment. It is not uncommon, particularly where it is a final judgment, for the order to provide for liberty to apply. And given the very serious far-reaching consequences of the judgment, which we've only just received, and therefore have not had an opportunity to fully consider, digest, and in the circumstances, even consult with our clients, I rise to ask whether the court might be prepared to add a liberty to apply provision to the disposition order, so that after we have considered the judgment more fully, if there's any clarification that we wish to come back to the court on, we could do that under the liberty to apply provision that I'm asking the court to make provision for now. And in relation to that, it could be, even though it is not for us to reply or respond on Ms. Mayhew's application, which concerns the government of Barbados, it could be that if the court is considering a further directions herein, that such liberty to apply as might be made within a specified framework and timeline could be revisited on any such further directions herein.
We would not have an objection to that proposed course suggested by Mr. Amor, my lords, but
yes, we don't have a difficulty in adding to the order liberty to apply, and it would seem that the most convenient thing would be at some point in the next court term to convene a hearing where we see what applications are wish to be made. Well, there's already one made, although quite frankly, it's a little embarrassing that that had to be made, because I think it is clear that the monies have to be refunded to Rockhard. That's the import of the judgment, I think. But we, and I say this without prejudice to any further order we might make on that score, but it might be appropriate that we accept your intimation that we include liberty to apply, and sometime in the next term, we will hear the specific application which has been made by Rockhard and any other application which might be made that seeks to tie up loose ends.
Very much obliged to the court.
thank you.
Arising out of that, as perhaps it may be covered by the ruling that you just made, that your order issued to D dismisses 2 applications, but says nothing about the other 2. So there may be, I don't know whether in the court's mind there are any residual issues to be determined there, or whether, so far as the costs which we're making submissions on is concerned, that we would treat it as though those applications have already been disposed of. So perhaps we could get some clarification.
Yes, well, those are the kinds of issues which could arise when we deal with the application in the new term that considers specifically the outstanding application that was filed yesterday and any other specific application that might be filed that indicates an uncertainty about what any particular outstanding issue, if there is, might exist in relation to the matters which we did not specifically comment upon.
Because of course it will touch and concern the cost submissions that we make. In other words, as I understand it, the court has ruled on that preliminary issue, if I may call it that, of the classification. And I take it that the submissions will be confined to those, save that the 2 TCL applications have been dismissed. So the cost can be, I suppose, more fulsome in relation to those applications. That's how I read it.
successful, and therefore due costs. Are you confident about making that estimation now? You can't do it now, but can you know? Okay. In the order that we will draw up, we will give greater specificity to the parties who we wish to go first in making their submissions on costs. Without prejudice to a party taking the view that, well, I should have gone first because on a particular issue I was successful and therefore I'm owed costs, or is it the other way around? But I think you understand what I'm suggesting. So
I see, Council, that your hope expressed earlier was not realized.
I say only this further, Your Honors. To the extent that what has just fallen from the learned president suggests that there may be a variation on who goes first on the issue of costs in the written submissions. I had not risen originally on the proposed timetable because I would not be going first given that I represent the losing party. But if the court were to consider that we should go first at all, I would ask for some extended flexibility on the timetable because I have commitments for the month of August that would make it very difficult for me to be putting in submissions by the 3rd of September. In fact, my commitments take me well into September. That would make it difficult if we were to go first on any issue.
We didn't consider that you should go first. You clearly going second.
Thank you.
Is there anything else?
The date for?
No, the date on which we will convene to hear the application filed yesterday, we have not yet identified a date. And, well, yes, it's pursuant to the ability to apply, but we will consider putting that in the order.
Once we have received the communication from the court with the attached judgment, we have forwarded to the council. So I have just received it by way of email. And simple to thank the court for its time in dealing with this matter and careful consideration, which obviously was given to the issues, and the, of course, erudite guidance which you all have delivered. So Mr. Miraj and Mr. Singh since asked me to convey that to the court.
Yes, thank you. So, that's it.
All rise.